Okay, so starting with the judgments for the week, we are starting with the very first judgment, that is VD Reddy versus V Manjunath. Now, over here in this judgment, what has happened is basically we are going to be talking about what is the liability that will be binding upon the co-partners where the Karta decides to sell a property in the interest of the joint Hindu family. Okay, so basically what this judgment or what had happened in this case was that the Karta had now sold off a property that was the joint Hindu family property to another person, which over here is BD Reddy. Now over here, upon selling it, when later the time for specific performance of the contract came in, at that point of time a case is filed not just against the karta but also against the co-partner. Now please remember the concept that we are trying to understand is kya agar ek karta, that is the head of a joint Hindu family, if he takes a decision for the benefit of the family, now if he sells a property, will that be binding on all the other members of the family who we also refer to as the co-partners? The answer is given by the Supreme Court in this judgment that yes, wherever the karta has alienated a joint Hindu family property for value, either for legal necessity. So there has to be two things that you have to see, that it is either for legal necessity or for the benefit of the estate. It would be binding on the interest of undivided members of the family who we also know as co-partners of the HUF or joint Hindu family. Even when, now please remember, Supreme Court has emphasized and gone one step beyond. They said not only the majors and males but also a minor as well as a widow will be bound under this sort of a sale. So this is what has happened in the very first judgment. Moving to the next judgment, we will be talking about Bijnor Urban Cooperative Bank Limited, Bijnor versus Meenal Agarwal. Now basically the question regarding mandamus has again come up. Now mandamus being a writ under the constitution. So basically Article 32 under the Supreme Court and Article 226 under the High Court's powers of issuing of a writ. This concept has now come forward. Over here, we are going to be discussing majorly article number 226, that is the power of the High Court to issue a writ. Now, what is the question over here? Now, can a writ be issued against a bank? That is what has come up in the enforcement of any scheme. Now over here, in this case, the scheme that was being talked about was one-time settlement scheme. So इसमें basically the person had wanted to settle his account once and for all. So he wanted to enforce a mandamus, that is compel a person to do an obligatory duty by the court. So he wanted to do this through the court. However, the Supreme Court has stated that over here mandamus cannot apply in the application of a scheme. Please remember, over here, one-time settlement scheme is a discretionary power of the bank. In this discretionary power, bank has the right to decide whether upon merits of that case, the person will be given the benefit of that scheme or not. So इसीलिए यहाँ पे कहा गया है mandamus will not be applicable under Article 226 against a financial institution or a bank while granting a scheme or the benefit of any scheme to a borrower. This is what was given in the second judgment for the day. Moving to the next one, we have the judgment of Buddhadev Karmakar versus State of West Bengal. Now over here, basically Supreme Court has reiterated, or basically they have resaid a statement that they had earlier given. That is, right to dignity is a fundamental right. Please remember, fundamental right under article number 21, that is right to life, recognizes right to dignity to all individuals in the country. Now over here, please remember what is the basic agenda? What was the major objective that the Supreme Court was trying to put forward in this case was regarding the rights of the sex workers in the country. Over here now, finally, the Supreme Court has given an ultimatum that all the states, as well as union territories, state governments, union territories, are now bound to issue ration cards, voter identity cards to all sex workers from the list which is maintained by NACO. So this is something that has been mandated because now a denial of the ration cards or voter cards to a sex worker has been considered as a violation of right of dignity of these individuals. Now, moving to the next judgment, we are talking about Anita Rani versus Ashok Kumar and others, again another Supreme Court judgment. Over here, what has been basically held? This is basically the concept of repayment. Where will be the burden of proof? Basically, who will be bound by owners? मतलब किसके ऊपर burden रहेगा to prove? जहाँ पे a person goes to a court and the purpose of going to the court is that मैंने किसी को someone had to give me money and that money has not been paid to me till date. Now, if you are going to the court for getting a payment or a due payment from another person, तो किसके ऊपर burden रहेगा to prove that? Let's say, for example, X files a case against Y in the court stating that I was supposed to be paid rupees 50,000 by Y. He has paid me 10,000 on an earlier date, but 40,000 abhi bhi pending hai. So now when this 40,000 is pending, who is going to prove? Where is the burden going to lie? To actually prove कि ये जो payment है ये pending है to X. This burden of proof will be on X. This is what has come out of this judgment. So the Supreme Court has held that when the payment of money and repayment of a portion of it is admitted by a party, then the onus, that is the burden of proof hota hai to establish that there was a full and final settlement of the dues is also on this party being X in this case. So जहाँ पे अगर आप कोर्ट में जा रहे हो and you say कि मेरे को पैसे देने थे मगर उसने दिए नहीं, court will say अच्छा जी ठीक है पहले आप prove करो. This is what has come out of this judgment. Moving to the next aspect, we have Ravinder Kumardhariyawal versus Union of India. Now over here, basically what has been discussed is the concept of right to equality. Right, now please remember right to equality and its various facets, that is the concept of right against discrimination. Over here, basically, a person who was declared 40 to 70% disabled. Over here, he had a mental disability. Issuing a disciplinary proceeding, that is, उसके against a disciplinary proceeding शुरू करना, was considered as a violation of his right to equality. And over here, it was clearly said by the Supreme Court that this will refer to as indirect discrimination. चाहे आप directly उसको कुछ नहीं कर रहे हो, you are not effectively discriminating him in his basic rights, but issuing a disciplinary proceeding against this person who was 40 to 70% declared as mentally disabled. Over here, this was a clear violation of his rights. This was considered to be against right of Persons with Disabilities Act. So his rights were clearly violated in this context. Now, moving ahead, let's talk about some bills and acts that have come in this week. We'll be discussing two bills and acts that have come in. First and foremost, not clearly a bill right now, but I hope everyone must have heard of this. This was all over the news in this past 1 week. That is, the Union Cabinet has finally approved an increase in the women's marital age. Now, we must firstly remember what was actually the marital age before this. Now, please remember, in 1978, the current ages of marriage were finally amended and brought into force. So 1978, it was said that 18 will be the marital age for the bride, that is the girl, and for the bridegroom, it will be 21 years. Now it has been recommended after a task force was appointed under Jaya Jetli. Now a 4-member task force was appointed to look into increase of this 18 years age for the women. Now over here, what was the basic agenda of actually trying to look into the increase in the age of marriage for women? Now over here, please remember health concerns, education concerns, and also on the third parameter, please remember health, education, and equality. These were the three parameters upon which there was discussion initiated to actually increase the marital age of women. Now, with this, finally, when this task force finally gave in their recommendations, they said for the improvement of these three parameters, we would suggest the increase in the age of women's marital age from 18 to 21. So now, finally, the Union Cabinet has also approved this in the last week. So, अभी तक सिर्फ अप्रूवल आया है. Please remember, marital age has been discussed under the Hindu Marriage Act, under the Hindu laws. So, and for the special laws, please, wherever there is a marriage between a Hindu and a non-Hindu, over there we have the Special Marriage Act. So, over there, please remember, in these two aspects, there will be certain amendments that will be initiated. So, let's understand what are the three laws that are going to be amended. Number one, we have the Child Marriage Act. This will be the first act that will be amended. So to prevent child marriage, a social evil that we have faced for many, many years, this is the first act that will be changed in respect of this. So amendments 3 आएंगी that will be in respect of number 1, Child Marriage Act, number 2, Hindu Marriage Act, and number 3, Special Marriage Act. Please remember, there will be, as of now, no change under the Muslim law, however, under which, please remember, under Muslim law, the marital age is dependent where the woman attains puberty. Moving to the next law, we have the law of Surrogacy Bill. So please remember, Surrogacy Bill, though it has come in the year 2019, it has now been passed both by the Rajya Sabha and the Lok Sabha in the past week. So what basically is surrogacy? And what all is this law going to talk about? Now, surrogacy basically is a concept whereby a couple that is often infertile or is unable to have a child for any reason. Now, where such a person now wants to have a child, he has certain ways and methods for the same. In the last session over here, we had discussed the concept of art bill, where technology coming in to help a person bear a child was talked about and dealt with. So art clinics, their board, their regulations were discussed in the last session. You can watch that video for the same. However, now moving one step ahead, we have the surrogacy bill, where in a form, a couple can, through the legal process, approach another woman beyond that family. They can approach another woman to bear their child. Now, this is what is the concept of surrogacy. It is legal, but it has two forms, which now are going to be looked into under this bill. Number one, we are going to talk about the types of surrogacy. One is commercial surrogacy and the other is altruistic surrogacy. Now, commercial surrogacy is where you pay another woman to bear your child, and then you pay all the other expenses for the bearing of the child. So you give her all the expenses for that tenure, the medical expenses, plus you give her added benefits, plus you give her money to actually go through that procedure. That is commercial surrogacy. On the other hand, altruistic surrogacy basically deals with the concept where this now will be dealt with. Basically, यहाँ पे क्या होगा? You are not really going to pay that person to bear your child. You are not going to pay a woman to bear your child. But only the basic reasonable expenses such as medical care, such expenses will be given. Now please remember the bill is going to prohibit commercial surrogacy, but it will allow altruistic surrogacy. This is a major step in surrogacy in India. However, also another thing to remember is surrogacy bill will be applicable for Indians only. So citizens can take the benefit of this bill. Now, under this bill, there have been certain categories of people that have been allowed to or have been permitted to go through surrogacy. Let's just quickly go through these. Number one, any couple that is who is suffering from proven infertility, that is, it has been medically proven that this couple cannot have a child due to their infertility. Next, it is altruistic, that I just explained that this has been allowed. So forms of surrogacy that are allowed, this. Next, not for commercial purposes. So where anyone is going to do this for a commercial purpose, where they're trying to gain a lot of means and benefit. Let's say someone tomorrow sets up an organization and they say, okay, come to us for surrogacy. We'll give you this criteria, so you can now bear your child to another woman. But for this, I will charge you 5 lakhs, 10 lakhs, whatsoever. Not allowed anymore. Next, not for producing children for sale, which will amount to human trafficking. Article 23 of the Constitution clearly gets violated. Prostitution, that is for sexual purposes or any other forms of exploitation. अगर आप surrogacy इन तीनों forms के लिए करोगे, it will be absolutely illegal. And lastly, for any condition or disease that is specified through the regulation. Now, multiple regulations, boards, authority are going to be set up for looking into the matters of surrogacy. And if they specifically state that is disease ke under you are allowed to claim it, then you will be allowed. So this is what your surrogacy regulation bill now is going to deal with. Moving to next. Some important events, days and appointments that have come in the last 1 week. Let's quickly begin. First and foremost, that is India and Australia signed an air bubble agreement under which all eligible passengers will be allowed to travel between both the countries. Now, why is this news relevant for us is because let's understand air bubble agreements. Now, we have seen this over and over again since the COVID-19 pandemic. This term has been used constantly in the news. Now, air bubble agreements are also known as travel agreements. So, basically what happens over here is one country, let's say X, enters into an agreement with Y. They negotiate some conditions and then finally they decide that we will allow passengers to move to and fro between these countries during the COVID pandemic under this air bubble. So, that is what is your air bubble agreement, where to and fro movement between two countries is allowed under certain parameters. Next, Catherine Russell has been appointed as the head of UN's Children Agency, that is UNICEF. Now, please remember here, this is in respect of United Nations International Children's Emergency Fund, that is the United Nations specific organization for children. Just remember this appointment as a relevant appointment for CLAT as well as for non-CLAT examinations. Next, Uttar Pradesh has topped the total registration of electric vehicles in India. Now, please remember, why are we talking about this is because electric vehicles, you have to refer to vehicle scrappage policy. Beyond that, do try to refer to the electric vehicles movement that is going on throughout the country today. So that is why Uttar Pradesh has, in this last 1 week, it has been declared as the state with the highest number of registrations in that respect. Now, moving ahead, the Union Minister of Social Justice and Empowerment has launched the National Helpline Against Atrocities on Scheduled Castes and Scheduled Tribes. Now, please remember, this is another step where we have seen a lot of cases come up in various parts of the countries in respect of atrocities against persons belonging to scheduled castes as well as scheduled tribes. So finally, now another major development that has come in is a national helpline has been launched in this regard. Now, moving to the last aspect, we also refer to the concept of geographical indications, or what you also popularly understand as GI tags. Now, very recently, Bihar's Mithila Makhana has been given a GI tag. Now, just to refer to which law deals with the concepts of GI tag or the protection of GIs, that is geographical indications in India, it is the Geographical Indication of Goods Registration and Protection Act 1999. So geographical indications basically is another form of intellectual property whereby now people can protect their property with a link to the geographical territory. So GI tags help us with that. For example, we have various aspects. Fulkari from Punjab, you have Banarasi sari, you have oranges from Nagpur, and so on. So these GI tags are helpful in the protection of these interests of a person who has been creating a quality product, and people were often used to manipulate or wrongfully take the benefit of the such type of products. So GI tags are another move over here. So Bihar's Mithila Makhana is another one that has been added to the list. Well, that is all for today. For more such videos, follow us on our channel HitBullsEye. Thank you, and I'll see you next week again.